Hey everybody, welcome back to the Law and Crime Network. We have breaking news this afternoon. We had been on verdict watch in California versus Michael Gargiulo. We now have a verdict in that case. Let's go right to the verdict. That is fresh out of the courtroom. Remember, we couldn't stream it live. The court said you can show it after the fact, which we've just done. That is the case against Michael Gargiulo, guilty on all counts, 2 counts of murder, 1 on attempted murder. So what does this all mean, and what did we see unfold here over the last few months? Chad Young, attorney, is here with me. Michael Corbonics, also here, former prosecutor and criminal defense attorney. Let me start with you. Michael, thoughts?
Well, I think this case was an uphill battle for the defense all the way through. I mean, this is really when you're a true criminal attorney, is you really don't have much to work with. Your client's chosen to go to trial, and you do the best you can. I know a lot of people were critical at points of this defense attorney with some of his
creativity.
Defense.
Yes.
Well, you know, sometimes any port in a storm. I mean, I give him credit. He fought the valiant fight, and he did the best he could in the situation.
Yeah, no, I thought he had some very interesting ideas about alternative suspects. Chad, what are your thoughts in general on the verdict?
You know, reasonable doubt was what the defense was trying to do here. Plant that seed of reasonable doubt that there are other people that had motives, there are other people that had opportunity. And I thought from a defense perspective that he did a great job of actually putting forth a reasonable doubt argument. Now, in the end, the jury didn't buy it, but hey, A for effort.
Here's my problem. And I got a lot of problems, but this is about this particular case. In California, they allow pattern evidence, signature crime evidence, as you were. And in this case, that meant the Illinois crime was folded into this only for the purposes of showing some sort of pattern. My problem with this is, it seems to me to be fantasy land stuff to think that a jury can separate that crime and use it just for the elements of his pattern or signature and apply them to the subject crimes in front of them. I think it can lead to results where maybe the prosecution's case ain't so good on the other cases, but hey, what the heck, we got what we don't have to decide from the Illinois case, we roll it into this case. Michael, thoughts on that?
Well, I always think that that's a dangerous road to travel for a prosecution. See, as a former prosecutor, I didn't want my cases to have questionable evidence coming in. I didn't want something that an appellate division can look at and say, you know what, maybe this had an overspill. There was so much prejudicial evidence from the case, as you pointed out, in Illinois, that it may carry over here. I think this case was so strong they really didn't need to go there.
That's interesting. I mean, I think it's a legal fiction which starts at the legislature saying, hey, here we can use it for this finite purpose, ignore it for any other purpose like guilt on that crime, jury. So, Chad, what do you think? To me, it's such an overwhelming benefit to the prosecution.
Oh, absolutely, it's a benefit to the prosecution. Look, some of the murders in this case, there was a lack of DNA evidence. Jurors today love seeing that DNA evidence. When you don't have DNA evidence, you have to find something else. So it was a win-win for the prosecutor when they could bring in all the murders, because then they could show the commonalities between all these murders, so they could argue, look, even though we may not have DNA evidence in murder 2 or murder 3, look, there are so many commonalities in the way that these murders were committed that it is a strong circumstantial case that he committed all of these murders.
Yeah, it's a piling on. I just don't like that. But the prosecution certainly took advantage of it. Let's listen to some of the closing that got this jury to this decision. Prosecutor Garrett Dameron said there, kind of made me think a little bit. He's talking about how tidy that the defendant was, and I'm not sure the defendant ever thought that being too tidy might come back to haunt him, but it sounds like that if you believe the prosecution. Michael Corbonics, you aren't real happy with this particular prosecutor and some of the things he might have said during this closing argument. Yeah,
there were points, not in this segment, but there were points earlier when I was listening to the trial where he I thought, took attacks at the defense for doing their job. And I think that's an ethical problem for a prosecutor. I don't think you should make it personal. Like, at one point he said, they expect you to believe they're distracting you. And that's not what a defense attorney does.
Right. I mean, basically
we're ethically obligated
he's lying to you, jury members.
Yeah, and as Chad said earlier, you know, we're there to make sure that they meet their burden of proof beyond a reasonable doubt. We're not there to deceive, to be sneaky, things of that nature. That's an insult to the whole system. And I'm surprised the defense counsel didn't take him to task on that. I sure would have.
Yeah, I think in California, they seem to be looser on a lot of things, and those are my homies out there in California. But I don't agree with everything going on out there.
I would have welcomed it to New Jersey, that's for sure.
Chad, what do you think about the impact of the sympathy in this case? I mean, it's a brutal case. Might as well get the guy there at the defense table. He seems to be the right guy. How big a deal is that?
Jury always, sympathy always plays a role with the jury, right? These were very sympathetic victims. Everyone can identify, I think, with these victims, knows some victims that fall into this category, probably has friends and family members that fit the general description of these people, and probably stay in fear for their safety. So yes, and jurors are human. Right, so sympathy is always going to play a role.
And if you add that little phrase, serial sexual killer, that never helps. Let's listen to a little more of the prosecution to see how they took advantage of the facts in their favor. Defendant smarter than everybody else in the room. Chad Young, we just heard the prosecution itemizing all the detail that the defendant was able to cover up because he watched the right shows. Who knows, maybe some Law and Crime, maybe we're partly to blame for these things. I mean, true crime is out there, it's everywhere. You don't have to do a lot to study it, but is this a case where the defendant just figured, I can cover my trail, easy?
Well, normal people aren't watching these shows to learn how to go out and commit crime. Normal people watch these shows because they might find interest in them and find it interesting how the people actually got caught. But they don't watch these shows for a how-to.
And yet, this guy, he didn't cite this show specifically, but he cited very specific shows, Michael Corbonics, that gave him some sort of how-to. I'm sure there's a YouTube for each of the things he had to do, and he seemed to be pretty effective in cleaning up his trail.
Well, it seems like he was really over the top, almost like obsessive compulsive kind of a thing here. But it's just such a direct target that he had in all his murders. It's just very scary, very scary.
And he really had a type and a victim that was similar in so many ways in so many locations. I get that. Certainly the jury didn't buy any of the defense arguments. What were those? I'm going to remind you what they are because we're going to go back to the defense closing arguments when we come right back. A verdict just in the Michael Gargiulo case, guilty, murder, and attempted murder. We'll be right back to the Law and Crime Network.